Hello everyone, my name is Ankit Aman and I am intern at ubAdvocate. I am a second year BBLLB student at Army Law College Pune, and today I have took the topic of defense of insanity under IPC. So firstly, we should know what is the meaning of insanity. So the condition of being seriously mentally ill is called insanity. And Section 84 of the Indian Penal Code says that any act done by a person who is of unsound mind at the time of doing act, and the person is incapable of knowing the nature of the act, and the person does not know that the act which he is doing is wrong or contrary to the law. So from where it came, law of insanity came. So it came from Mcnaughton case, which was there was various tests used to declare a person legally insane, such as wild beast test. This test was the first to check the insanity laid down in the case of Arnold. In this case, it was held that if any person do not have the capacity to determine what is right or wrong, then he would get insanity defense. Then came the insane delusion test and test of capacity to distinguish between right or wrong. These three tests laid the foundation of the Mcnaughton rule. In 1843, the accused, so now we should know what was the facts of the case. So in 1843, the accused Mcnaughton was suffering from persecution mania, and because of this disease, he thought that whatever the difficulties he is facing is because of British Prime Minister Robert Peel, and Mcnaughton shot Mr. Drummond, believing under a mistake that he was killing Prime Minister, who was the private secretary of PM, and this happened because Mcnaughton was sick. So he pleaded insanity and the House of Lords acquitted him. This generated a lot of public sentiment, and lot of pressure was put on the House of Lords, and they constituted a special committee of judges and laid down the rules for plea of insanity, and this is known as Mcnaughton rules. So these rules are as follows. Firstly, all are presumed to be sane until contrary be proved for the satisfaction of the court. Second, to claim the defense of insanity, one should clearly show that at the time of the act, the accused was suffering from the defect or mental illness. Third, at the time of doing act, he did not know the nature of the act. Fourth, at the time of doing the act, the accused do not know the act what he was doing was wrong. So, English law considers insanity as a valid defense. The definition of insanity is based on Mcnaughton rules. Now we come to Indian law. What is the concept of defense of insanity under Indian law? In India, the law on this subject is mentioned under Section 84 of IPC, which I told you earlier. The provision are same as mentioned in Mcnaughton case held by House of Lords. By the way, Section 84 use a more comprehensive term, unsoundness of mind, rather than word insanity. So let's see what are the essential ingredients of Section 84 of IPC. First, act must be done by a person of unsound mind. Second, such person was unsound at the time of committing the act. Third, such incapacity should be of unsoundness of mind of the accused. Fourth, such person was not capable to know the nature of the act, or the act he was doing was either wrong or contrary to the law. Then now come to the distinction between legal insanity and medical insanity, because it is important to note that insanity plays a vital role in criminal law, and it is legal sense is to be understood rather than medical sense in order to claim defense under IPC. Legal insanity is narrower than medical insanity because some illness which are termed as insanity according to medical science, but it cannot fulfill the criteria of legal insanity in order to get the defense under IPC. So now we can see the difference between medical insanity and legal insanity. Medical insanity, which is according to medical science, unsoundness of mind or insanity is a type of disease which messes with mental faculty of a person. This disease in brain or nervous system leads to working of one or two function of brain in an abnormal way, or these functions of brain do not function at all because of the disease in brain. And now legal insanity of the insanity is different from medical conception of the insanity. Not every kind of insanity is made excusable in the eyes of law. Section 84 of IPC cannot be invoked unless it is established that accused was suffering from legal insanity. To invoke the benefit of Section 84 of the IPC, it must be proved that unsoundness of mind was of such a degree which should be capable to fulfill any one of the tests laid down under the section, and they are: first, the accused was incapable of knowing the nature of the act, and second, the accused was not capable of understanding that what he was doing was either wrong or contrary to the law. Now, these are some of the natures of the act. Incapability to know the nature of the act. To get the defense of this, one should prove that insanity should have affected the cognitive faculty which guided our actions. Second, incapacity to know right or wrong. In order to use the defense of insanity, it is not mandatory that both the requirements mentioned in the section have to be fulfilled. A person, if able to know the nature of the act but not able to know what was wrong or contrary to the law, can still get the insanity defense. And third, burden of proof in the cases of insanity. There is very much burden on the prosecution. The prosecution has to prove the offense beyond reasonable doubt. But onus of proving the elements mentioned in Section 84 of the IPC are on the accused, which is also mentioned in Section 105 of the Indian Evidence Act. To claim the defense of insanity, defense have to prove that at the time of the occurrence of the incident, accused was unsound mind, and the rules for burden of proof in cases of insanity are as follows. First, prosecution have to be proved beyond the reasonable doubt that the offense was committed by the accused with mens rea. Second, insanity is a rebuttable presumption. Third, the accused can bring oral, circumstantial, or documentary evidence to rebut the presumption of sanity at a time and claim defense of Section 84 of IPC, and accused do not have to prove elements of Section 84 of IPC beyond reasonable doubt. Fourth, even if accused is not able to establish the ingredients of Section 84 as to the act committed by him but still creates doubt in the mind of the court, then the court would be entitled to acquit the accused on the grounds that the general burden of proof resting on the prosecution was not discharged. So this was all for the today's topic, and thank you